have two cases on the docket this morning, and we will take them in the order in which they appear. The first case is Sylvia versus Castle Key Insurance Company. And counsel for the appellant, you may proceed when you're ready.
Thank you, Your Honor. May it please the court, I'd like to reserve 10 minutes for rebuttal,
So
if I
noted.
may. That's okay. All right. Your Honors, the issue in this case, let me stop for a second. My name is Stephanie Taylor, and I'm appearing on behalf of the appellant, the plaintiff below, who is Joseph Sylvia. The issue presented in this case is, did the appellee, Castle Key Insurance Company, waive its right to appraisal under the insurance contract by defending this case on the merits by filing an answer with affirmative defenses and requesting a jury trial and responding extensively to discovery without ever in any of those pleadings or the discovery request appraisal, file a defense saying appraisal is due. An appraisal was not requested until after all of those were done and after they requested from us a settlement demand, which, by the way, a monetary number was never given in that settlement demand. We just gave them additional information. Another way to word the issue is, did the court below err in granting Castle Key's motion for reconsideration on their motion to invoke appraisal? And we feel yes, in both cases, the court below did err in that and relied on the cases from this district, Wooden and Norton, that are inapposite and do not apply to these circumstances. So this case arises from Hurricane Michael. Mr. Sylvia suffered damage. Some trees fell on his house, other structural damage. That damage was investigated by Castle Key early on at the end of 2018, and some monies were paid on that. Throughout the next year and a half, and this is seen in the discovery responses, so you'll know where this information is, and it's on page 153, for example. Of
so,
the
counsel, so you're going to concede the statements in the discovery that are in the appendix as those are the facts that we're dealing with? Because I didn't see anything that was putting any of those facts in dispute.
Right. We're conceding that the facts are not in dispute, except, well, the only thing I would say that could be in dispute and is not, the document itself is not in the record, is one of the, of Castle Key's position is that they did not have enough information until we gave them a monetary demand. As I make clear when I am arguing before the court, we never gave them a monetary demand. There was never an amount. They had requested some information. We had an estimate that had been prepared by one of our experts, which we forwarded it, but we never requested an amount at all in that letter that was forwarded.
One of those, and those, that is referenced in the discovery, this estimate?
That's it's not referenced in discovery. It's referenced in the transcript from the hearing below.
Right, and that's a statement from counsel, though. I mean,
Well,
there's
correct.
no testimony about it.
Well, and exactly, Your Honor, whether or not there was ever an actual demand as well is all just statement
Right.
from counsel.
But you'll also acknowledge that the insurance policy, which is actually not in the record either, has that appraisal provision in it?
Yes, Your Honor, it does. And we are not disputing at all that there are instances in this case, there is a contractual right to appraisal. But our position is that was waived by several of Castle Key's actions in the underlying case.
Is it a right or an obligation?
It's a right. We don't believe it's an obligation. Either party can request it. They're not obliged to do so. It says they can, and I believe it's on the record on page 69. Defendant does correctly cite what that provision of the policy says, indicating that it's a right if there is a dispute as to amount of loss. And I don't think any court has ever found that it's an obligation unless it has been demanded correctly and then the other side is obliged to appraisal if it is so requested. But if not, it's waived.
And what happens with in your view, so if, let's say the appraisal process actually did go forward at some point,
Yes.
what happens at the end of that? Like when you get a number from either the two appraisers or an appraiser and the umpire agree, whatever?
Your Honor, that depends on when it was requested and the actions before that. For example, if there had been a civil remedy notice filed previous thereto and a lawsuit had been filed and had been stayed, often what will happen is it will go to appraisal, and then it will come back to the court to determine if there are fees due, interest due, and costs due. If it's requested before litigation, and sometimes after litigation, early on like it should be, it has to be raised in the initial pleading. Not a motion for a more definitive statement, but it must be raised in the first responsive pleading.
Where do you get that from?
There
that
are several
idea?
cases, but Johnson versus Nationwide is the primary case. Bronco talks about that. Several of the cases, Saldukas, I believe, Your Honor.
Right, but in the context of appraisals or in the context of arbitration?
Well, some of them refer to it as appraisal and some in arbitration, but
Actually, most refer to it as arbitration, and in taking steps in litigation to actually litigate a case clearly is inconsistent with arbitration, because arbitration is an alternative to litigation. But my question is, and I'll cut to, here's where I'm really going with it, is appraisals are different. Because there's not an adjudication, you still have to do something with that number, and it can presumably be a breach of contract in some way if the parties don't honor the appraisal pursuant to the insurance provision. What is it about just answering a complaint and litigating for what was this, like 5 months before? I mean, from
About 5 months,
filing
Your Honor.
until the
Yes, sir.
demand. What is it about the initial actions of the insurance company that is inconsistent with the idea of seeking an appraisal?
And first, Your Honor, I would disagree that an appraisal is an adjudication. You cannot get the appraisal overturned. Those numbers stand as if the same for an arbitration.
Sure, but you can't file it as a lien. You can't get it confirmed. You still have to do something in court and get a judgment on it, which is
That's
different
true,
than
Your
an
Honor.
arbitration.
We do have to move to get it confirmed if they do not pay that. And I honestly don't know in an arbitration if the people didn't pay under arbitration, if that would be the same. They may also have to get it confirmed. I don't know the answer, but it may be. But Your Honor, here's what happens is when somebody files an answer to a complaint and they defend on the merits, on the justice, what's included in the cause of action, and they defend, make defenses on that cause of action on the underlying case, they're waiving their right to appraisal because they're taking a position inconsistent with it knowingly and intentionally by not waiving it. The line of cases is clear on that. All the cases in Florida say that if you don't raise that, then you're waiving it.
Well, I mean, you're sort of equating it to a statute of limitations, to me, where you have to raise it in the first responsive pleading or it's waived. But in this context, quite often, and you'll see this flowing throughout these cases, you don't have a specific or concise complaint with respect to damages, and that's understandable. You still have discovery to go through. So when you have somewhat of an ambiguous or broad allegation in a complaint, don't you think there's a problem with triggering that duty in the form of an answer to raise appraisal immediately or waive it when, quite frankly, you may have still questions about, do we have a coverage issue or are we just disputing the amount of damages?
Your Honor, I don't think it's a problem because if there is an ambiguity in the complaint, you don't have to file a responsive pleading. You're not going to subject yourself to a default. What the defense can do and should have done in this case if there was a concern, but there wasn't. It was clear what we were pleading.
And I think your case is distinguishable from the other cases because
Yes.
I look back at you actually had quite a specific, in my opinion, complaint. In fact, you said refused to timely provide adequate compensation for plaintiffs' covered losses.
And that is all we pled.
And I thought that was pretty specific as in compared to Norton and Wooden, etc. So I think, would that have put them on notice adequately that this is not a coverage issue, this is a damages?
And Your Honor, it did put them on notice adequately because they responded. They filed an answer. And to that particular count, or not count, but that particular paragraph, they denied that. Then they filed affirmative defenses in regard to damages. So they understood our complaint. This wasn't a case where they needed to file a motion for a more definite statement. They understood what we were saying, or at least acted like they did.
Do you think that's complemented by, for example, interrogatory answers 5 and 6?
I do. And you can see, particularly in 5 and 6, where they continued to adjust the claim, and at the very end, there was an issue about windows. Mr. Sylvia was claiming money for windows. The defendant, Castle Key, did not pay that and essentially said it wasn't causally related, if you will. And so they knew at that point that we were claiming something, Mr. Sylvia, that they weren't paying. And they had already, by the time we filed suit, had 2 years to fully investigate and adjust the claim. They knew there was some amount outstanding. There's no requirement that they have to know the specific amount. And sometimes people may not know, because if they're not paying because of causation, in this case, they're saying the windows aren't caused, there's no requirements that we give them a settlement demand of a specific amount. And in fact, this case, we never did. So I don't think they can even use that as a defense here to support their position, because no settlement amount was ever asked for, and that's not the case law here. It was ripe for appraisal well before we filed suit. We're not saying that they couldn't have requested it after we filed suit, but in their first responsive pleading, which would have been an answer they needed to. Now, if they had done a motion for a more definitive statement because it was ambiguous, as happened in Wooden and Norton, that would have been okay. That's not a responsive pleading. But
So, for clarification though, is it your argument that it's waived because it wasn't raised in the first responsive complaint, period? Or in the alternative, if we don't accept that argument, it certainly was waived based on their conduct post-filing of the answer?
Your Honor, it's in the alternative, because the underlying cases say you look at the totality of the circumstances, not just the length of time of litigation, not just what was filed, but is the action they're taking inconsistent with their right to appraisal? And all of those actions they took, Your Honor, are inconsistent. Filing an answer that never waives appraisal. They knew we were asking for additional compensation. At that point, they had already investigated the claim and adjusted the claim. They knew that if they wanted to go to appraisal, we're talking about amount here, which amount of loss is what the contract says is appropriate for appraisal. And yet still they did not request it. Rather, they defended on the merits with an answer. And they requested a jury trial. I mean, that is one of the most striking inconsistencies I can find. If you are requesting a jury trial, you're certainly not wanting an appraisal. And in the complaint, again, it was purely on compensation, which is the amount of loss, which also includes the cause of the loss, which was really the main issue here, underlying where they denied the coverage for the windows.
Counsel, before you sit down, I did want to ask you about your motion for prevailing party fees, assuming we get to that, and assuming we do find that you are the prevailing party. You cite to section 627.428. However, this court has recently concluded that section does not authorize prevailing party fees for interlocutory appeals. I don't know if you're familiar with that case, and if you are able to distinguish it in any way.
I am unprepared to answer your question. I have to admit that, and I apologize, Your Honor. I am not, but if there is any opportunity, if we do happen to win the appeal, we will certainly amend that, and if there's another appropriate case or statute to rely on, we will do so.
Okay,
Thank you.
counsel.
Good morning, Your Honor. I'm Jerry Sanders. I represent the defendant Castle Key Insurance Company, appellee in this matter. The first question I wanted to answer was of Judge Tenenbaum, and that was why the demand that we're talking about that came on January 7th, 2021, was not put into evidence. It was styled a confidential correspondence in settlement negotiations. And so in order not to initiate litigation or to be a party to extensive litigation and not to have violated that provision of settlement negotiations, we couldn't put it into evidence, so we didn't put it into evidence. But I had to mention the fact that that's when we first got a demand and knew what it was about in our motion for reconsideration, obviously, or in motion to enforce appraisal. And so it's a fact, it's not disputed, counsel argued it, it's certainly not a factual issue. I don't think there's a factual issue involved, that that's the first time we got a demand or knew that there was a dispute, actually. As was cited in my brief, there was no indication to Castle Key, and it hasn't been refuted by counsel, that there was a dispute concerning the initial adjustment of the claim at all. No demand letter, no letter of dispute from the insured, from anybody, until suit was filed. So we filed a simple answer, and then we were requested to respond to discovery, and which made sense to us, because perhaps counsel didn't know that it had been adjusted previously, because perhaps the insured was mistaken about the adjustment that was previous of the claim.
But you knew that the complaint was claiming the amount of loss, or it was, the suit was based on what they contend with. We weren't paid our covered losses. And if that's the case, why demand a jury trial as opposed to demanding the appraisal at that point?
I don't think it is that clear. I'm sorry. That's not, our interpretation was, well, perhaps counsel was mistaken. Perhaps I didn't understand that this had already been adjusted, this claim had been adjusted. It's really vague language, in my opinion, in the complaint. There wasn't any monetary demand in it, as you know. It's just you breached your contract and you didn't pay the claim, essentially is what it's saying. And so we said, well, maybe they do need discovery. Maybe they do need to see that we actually have paid this claim previously to understand it. And I did start right away asking for a demand, or what was in dispute. Have you got a demand? Have you got an estimate of what it is that's being claimed? Is there something that this is based upon? And I didn't get it until January 7th, and when we, within, say, 8 days, invoked appraisal. That's
So
what happened.
if you look to our cases that you brought to our attention in Norton and Wooden, they stand for the proposition when that a complaint is vague and you need more information, that a motion for a more definite statement would be appropriate in those circumstances, and certainly it's not inconsistent with the right to appraisal. Do you disagree that that would have been an appropriate tool to use here and would not have amounted to a responsive pleading?
First off, I think it's the Wooten case, not Norton, came out of the 14th Circuit, which is one of the circuits we practice in, Panama City. And there'd already been ruling. In fact, then that was one of the rulings that we knew about, where the trial judge at that time and the trial judges were saying, you file a motion for a more definite statement and you have waived appraisal. That's what they were saying. We didn't know that the court was going to say that's not a waiver of appraisal. So that's one of the reasons we didn't file it. Number two was, I'm sort of an advocate, an old-time advocate of Professor Trawick, who says the motion for more definite statement is a useless anachronism, that under our rules of pleading, for simple statements of pleadings and the case law which interprets it, that the complaint must be, and all facts well pled in the complaint must be accepted as true on the face value, and any motion to dismiss must be based upon the four corners of the complaint, that a motion for more definite statement is just pointless. You can respond to any complaint by saying either admit it, you deny it, or we can't admit or deny it because you don't give enough information. So I've sort of been an advocate of his, and he, in his treatise, says that it's not a appropriate motion to ever be made. So that's one of the reasons, and plus, of course, the lower courts at that time had been ruling that was a waiver of appraisal.
Counsel, could you address the argument that, for example, interrogatory 5 and 6, which were filed in November, the responses to those, to me, don't seem to indicate that there's any coverage issue whatsoever, that it's strictly a damages type dispute. Could you respond to that?
Yes, that we agree. That it was, at that time, we determined it was damages only, and here's what we paid for damages. Not a coverage dispute, no, but a dispute as to whether or not you understood, we've already paid this claim, we paid damages. They
Right,
were-
and I appreciate that concession, so then why are we waiting till mid-January to ask for the appraisal?
We didn't know that there was amount in dispute, remember? They had never given us any indication there was any dispute
Doesn't
whatsoever,
the filing of the complaint
other until filing
sort
complaint.
of indicate that we dispute, that you haven't paid us enough?
Maybe they didn't realize they'd been paid. I mean, how was I supposed to know? We hadn't gotten any information before, there'd never been any kind of pre-suit notice, notice of intent to initiate litigation, anything.
Why not include it in your affirmative defenses at least?
Probably should have, although I'm not sure, most of the appellate courts aren't too thrilled about affirmative defenses, as you know, and they don't generally support them, so we don't try to over-inundate pleadings. Plus, of course, are we supposed to not initiate litigation? Are we supposed to, try to get to the appraisal stage as quickly as possible, if it is appropriate for appraisal, which we didn't know until January?
What was it about January? What was the specific piece of information that in your mind, that was the-
Estimate came from a counsel, January 7th, in the confidential settlements demand that says, this is what we're claiming, and this is what the dispute is about. And that's the first time we knew about it. And that's undisputed, and it's admitted, by the way, in the transcript, by the way, that was referred to by opposing counsel. I'd only refresh the courts to one thing, and that is the leading case on appraisal in general and waiver is, and I quoted in the brief, and that is the Florida Insurance Guarantee versus Marolas case. Now, the question of waiver of appraisal is not solely about the length of time the case is pending or the number of filings the appraisal-seeking party has made. Instead, the primary focus is whether the party acted inconsistently with their appraisal rights. We don't feel we did under these circumstances. We didn't know about what was in dispute or that it was any dispute until January 7th, and we invoked appraisal within 8 days.
What, would you acknowledge that there is a point on, if there's a time continuum from the filing of a suit to trial, at some point along that continuum, it would be too late, where the insurance company would be considered to have, I would call it forfeited, not waived, but forfeited its right to an appraisal. Where do you think that, where would you have us draw that line? Like, what would be the criteria that we should apply to determine how far the insurance company has gone where it's too far?
I think if we had filed discovery of our own, I think if we had filed motions of our own, I think if we had asked for depositions, then yes, that would be too much.
And what is it about those things
That's engaging.
that would be
I'm sorry.
inconsistent with seeking an appraisal, whereas filing an answer and demanding a jury trial and producing discovery would not be?
Well, that would be the engaging in litigation. We didn't engage in litigation. We
Well,
just,
it can't, so, and that's what I'm struggling with also. I mean, I know that these cases talk about it, but this idea of engaging in litigation derives from arbitration cases originally. And clearly appraisals and arbitration are different. And I can see where engaging in litigation is wholly inconsistent with seeking arbitration. Not necessarily the case with respect to appraisal, because an appraisal is determining, it's an alternative means of determining the loss amount, and you still have to bring it back into court. So it's not, it can't just be just engaging in litigation, which your client did actually in this case too. Presumably it's going to be more, and like even Bronco, it was the plaintiffs. I mean, they themselves filed suit, engaged in litigation for what, 2 or 3 years, and then decided on the eve of trial, we want an appraisal. That's probably at one end of the continuum. Where do we draw the line at the other end, where the insurance company will have gone too far versus not? And it can't just be engaging in litigation, because that would mean doing anything in response to a complaint would forfeit your right to an appraisal. right?
I agree. I think probably, looking at it logically, it would be, once you know what is in dispute, once you know what the damages are being claimed, if you don't invoke within a reasonable period of time appraisal at that point, yes, you waived it. Well, we didn't act inconsistently over an extended period of time. Within 8 days of finding out what the dispute was about and what the amount was, we invoked appraisal.
And is that a fact determination that the trial court's supposed to make?
I believe it would be if the facts were in dispute. Yes, it's factual determination, sure.
And where does that leave us here, like in terms of the record and what the,
I don't think
what
it's-
supports the determination that your client, as soon as it knew what was in dispute, it filed its
I
demand
didn't
for
think
appraisal?
that was in dispute factually. There's been, you can see from the transcripts of the hearings that counsel on both sides stated that was the facts and they weren't disputed. I don't
Yes,
think
but
they are in
the
dispute.
grant of the motion was pretty much summarily granted. There was no discussion, citation to the two cases, but no explanation by the trial judge.
True. We have the transcript of the hearing, though, which is filed with the record, or filed with the appendix, excuse me, that shows where the counsel both argued that.
Put it a different way, who bears the burden of establishing that, I don't know, either that your client didn't forfeit or that your client appropriately claimed right to an appraisal?
Well, I think the burden of proof would be, of course, on the party opposing appraisal, at least the burden of, and then the burden of going forward. Once they established a prima facie case, then we would have the burden of proving that we didn't waive.
But aren't you seeking enforcement, essentially, you're seeking an enforcement of a contract provision?
Correct, yes, sir.
So wouldn't the burden be on the movant? Or you're saying
Burden
that
would
the
be on the movement to establish a prima facie case, yes. We have the right to
Okay.
appraisal in the contract. Here it is. We have a notice, so we've done that.
And then the forfeiture as a defense would be on the
Would be
other
on-
side, is
yes.
what you're saying? Okay.
That'd be my opinion. And thank you, ladies and gentlemen.
Okay, thank you, counsel. May proceed.
I don't know if you would consider this a factual dispute, but counsel for Castle Key again states that they had no notice there was any dispute until the complaint was filed, which isn't correct. Again, if you look at those discovery responses, you will see that at least there was an amount in dispute or causation for the windows, which claimant had an estimate and they denied payment on. That's clear. Also, and while the letter is not in the record, the reference to our notice of representation that we filed with Castle Key on August 11th is in the record on page 73, and another letter that we write to Castle Key telling them why we're objecting to their basically their motion to invoke appraisal because it's untimely and waived. We refer to our letter of representation there, and then also in the transcript of the hearing, I refer to it on page 66. So we have facts underlying here where Castle Key never responded to that for 45 days. Florida statute requires them to respond within 30. So we never got a response. So what is a plaintiff to do if they're not getting a response from the insurance company but file a complaint? We know there's a dispute. Our client does. Castle Key should know because they denied coverage for the windows. Maybe they think that the claimant's just going to accept that, but it's not the case. And the long line of cases here clearly show that a case is ripe for appraisal when coverage has been acknowledged and the claim has been adjusted and payment made. The other side is conceding that. So we know that it's already ripe. It's not the issue of was it right before or after litigation. It was ripe well before litigation and it was never requested. Our case doesn't stand on that premise, but I just would like the court to know we have a 2-year period still where they haven't requested appraisal. Perhaps they did think the claimant went away. The plaintiff decided they weren't going to dispute the windows. I don't know. But certainly within a few months after that, we did our notice of representation and never got a response. So at that point, our only avenue was to file the complaint specifically for the amount of loss, for compensation. The cases we believe are clear that say that that right to appraisal, it's a contractual right, has to be safeguarded. And in order to safeguard that, it needs to be pled before you do anything inconsistent with it. There are several things that Castle Key did that were inconsistent throughout, and they knew there was a dispute in the complaint. They were able to intelligently respond to the complaint. One cannot argue that they did not, because they did. The rules of civil procedure provide that if something is so vague and ambiguous you can't figure out what is being claimed, you can file a motion for more definitive statement. While Trawick may disagree with that, that is the current rule. Those are the rules that the Florida Supreme Court has adopted. And that is the appropriate action to take, or in the first response of pleading, an answer to bring up the fact that appraisal is appropriate here, either invoking it or bringing it up as an affirmative defense somewhere, and not requesting a jury trial, which was done here. Again, it's a red herring saying, well, we don't know what the amount was. That's the whole point for appraisal, because people don't know the amount. So request it so we can figure out. The very fact that Castle Key asked for a settlement demand shows they knew what was in dispute, the amount of loss. That alone shows that they knew that it was ripe for appraisal. They knew the amount of loss was at issue. And then there are cases where the plaintiff may not know exactly how much is at issue. An example is, as in this case, if you didn't have an invoice, our client did, but say the windows should have been covered, but you don't really know how much the windows are going to cost because they said it's not causally related. Well, that's when you ask for an appraisal. But it defies the case law that we have that's long-standing that says that a settlement demand must be given, or it's not ripe until after that because they don't know the specific amount. But going to amount, our complaint says it's more than $30,000, and then in the civil cover sheet, it's marked between $50,000 and $75,000. Okay, and that is in the record. So there are clearly amounts marked. And in the settlement letter that we sent, we don't ask for a specific amount. We just say, hey, here's what our expert did. Look at it, see what you think of the scope.
Do you agree with the assertion that the burden would be on your client to submit evidence of forfeiture if there were a need for that?
A forfeiture of their right to appraisal? Yes. Submit evidence on that?
Sure. I mean, isn't it sort of a mini evidentiary issue? So they're seeking to enforce a contractual provision. They raise it as by motion. You're claiming it should be denied because they forfeited it. Isn't that, and if it's an evidentiary question, don't you bear the burden of submitting evidence to show forfeiture?
I think that's fair when it does become an evidentiary question. Again, here I think the evidence is clear.
Which is what?
The evidence that's been waived. Well, that
just the pleadings.
Well, the pleadings and the discovery responses. If you're going to rely on the fact that they said they got a settlement demand, they didn't have an amount. That's in the record. They never responded to our letter of representation. How long are we supposed to wait for that? They usually have 30 days. We were well past 30 days by the time we filed suit.
Does it matter, though, that your client dumped not only the complaint, but a lot of discovery, typical, lengthy with definitions and instructions and everything else, the typical civil litigation discovery, dumped all of that on them at the same time? Does that matter that maybe they should respond first and then deal with the appraisal issue?
No, Your Honor, I feel the fact that they actually did respond matters because, again, that shows they are responding to the specific issue of amount of loss. They're submitting that to the court here rather than just stopping and say, we think appraisal is appropriate at the point. At least let the court address it and the court make a ruling. As in Wooden or Norton, the lower court got it wrong, but the insurer was forced to go through some discovery, otherwise potentially subject itself to sanctions. But it had done a motion for more definitive statement, which is what this particular district has said is what is necessary if you're going to preserve that right, or at least claim that right as an affirmative defense or somewhere in your initial pleading. So again, I believe on the totality of the circumstances here, they have waived that right to appraisal. And again, this could have gone on for years. Maybe they didn't like where it was going, the court, and then it's almost changing horses, you know, mid-race. It was ripe at the time we filed suit. Well before that, they should have at least claimed it because it was clear that we were claiming amount of loss was at issue. They understood it because they responded to that and even did affirmative defenses in regard to the amount of loss.
Thank you, counsel.
Thank you very much for your time.
Thank you, both attorneys. We appreciate your arguments today.
Thank you.